ranging from the year 2023 all the way to 2025. The amount in this question as of 10th of June 2025 is 351 million shillings. The governor for Kericho is also facing accusation of misappropriation of funds and unfair distribution of a projects fund under the Financing Locally Led Climate Change Action, FLOCA Fund. And under this charge, the governor is facing the charge of misappropriation of funds, where for the better part of today afternoon and tomorrow, if the Senate this afternoon decides to continue with the hearing of the matter, the House will be determining on Friday whether he is guilty or not guilty. That is through the upholding of the impeachment by the County Assembly or quashing that impeachment by the County Assembly of Kericho, and thereby letting the governor to continue with his duty of being the county boss of Kericho County. On the three grounds for impeachment, the Constitution provides that in the event either of the charges acquires the requisite vote to uphold it, one charge is enough for the governor to have been considered as impeached by the Senate. Ground number 2 is on misuse and abuse of office, where the governor will be seeking to defend himself before the Senate plenary on the illegal appointments, unlawful dismissals and transfers, as well as usurpation of the constitutional and statutory functions of the county public service. In the documents before the Senate, the governor is said to have abused his office by way of skewed, uncompetitive, and nepotic appointments of the county employees of various cadres. For instance, the members of the County Assembly of Kericho say the governor recently hired his own brother, one Victor Mutai, as a revenue clerk, and similarly, the governor's personal assistant's wife who was recently hired on contract basis as a nurse, was confirmed. Yet there are a number of nursing staff who have been serving on contract for a long period without having been confirmed by the County Assembly. The other ground that is facing the governor for Kericho, and in which himself as well as the council are representing him, they will be seeking to show the Senate that the charges before the Senate are not as watertight, is the aspect of gross misconduct, where Governor Erick Mutai is facing accusations by the County Assembly of bullying, incitement, vilification of people and the county staff. Members of the County Assembly have quoted the provisions of Articles 10, 73, and 75 of the Constitution, as well as Sections 29 and 34 of the Leadership and Integrity Act. And they are accusing the governor of operating with impunity as though he is above the law. The MCAs say that on the second day of being sworn into office, the governor led a mob to divide a private land owned by one Mr. Josiah Kiplagat Kogo within Kericho County and tore the office fence. This is among other issues highlighted by the County Assembly. The MCAs also say that none of the dismissed CECs or CEOs, as well as chiefs of staff and other senior county staff, were given fair administrative due process to matters to do with the hearing of their case, and thus violating the provisions of Article 41, 47, and Article 50, subsection 1 of the Constitution. The governor is also facing the accusation by the members of the County Assembly, where MCAs, in their submissions before the Senate, are accusing the governor of persistently intimidating, molesting, and harassing county officers who do not sing to his tune, leaving officers jittery and creating an atmosphere of fear, uncertainty, and despondency in the county, and thus creating a toxic work environment. This, according to the members of the County Assembly, is in violation of the provisions of Sections 11 and 13 of the Leadership and Integrity Act of 2012. The other issue that the governor will be seeking to debunk at the Senate is the matter of persistently being divisive and unbecoming and using unbecoming language, which is undermining the office of the governor that he holds. This is contrary to Section 8 of the Leadership and Integrity Act. In the submissions of their charges that the members of the County Assembly through their council are seeking to have the Senate uphold the impeachment, the members of the County Assembly say the acts of the governor as enumerated before the Senate have collectively brought dishonor and disrepute into the office of the governor in violation of Chapter 6 of the Constitution and the Leadership and Integrity Act of 2012. Remember, our dear viewers, public officers are mandated to uphold the integrity in the various offices or constitutional offices that they hold. And this is equally the second time that the governor for Kericho will be appearing or is appearing before the Senate, facing a similar matter on the impeachment. On the first juncture, the Senate threw out an impeachment facing the governor. But yet again, the governor has found his way yet again at this Senate, where he will also be seeking to have the House save him from the impeachment that is facing him. Remember, the County Assembly of Kericho impeached Governor Erick Mutai on 3 charges as provided for in the 2010 Constitution, being the grounds on which the members of the County Assembly may send their governor packing through the impeachment. That after the members of the County Assembly have passed a resolution to impeach the governor, the matter finds its way before the Senate, being the House, that is charged and is mandated by the Constitution has the role of hearing and determining matters to do with impeachment of county bosses. And the governor for Kericho is seeking to have the House save him for a second time. The senators will have to hear from the side of the county governor, as well as members of the county assembly through their representatives, that is in form of lawyers, the governor himself, witnesses before the Senate, as well as various evidence that will be adduced before the House before reaching a conclusion. That would be by way of voting on the 3 charges that the governor is facing. And according to the House rules and procedures of the Senate, the senators will be voting on each and every charge facing the governor, and in the event the number of 25 senators is achieved on either of the charge, the governor will be considered to have been impeached by the Senate. But in the event those charges are shot down by way of lack of the requisite quorum, the governor will have survived. Allow me to hand over back to the Senate or for this live proceedings of the Senate. Good afternoon.
Ewe Mwenyezi Mungu, twakusihi ututazame kwa neema nyingi na baraka, sisi watumishi wako ambao umeridhika kutuita kwa nyadhifa za uongozi katika jamhuri hii yetu. Tukuomba utuwajalie tuyatende na kufikia mambo yote atakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. Clerk, do we have quorum? Order, honorable senators, we do have quorum. Senator for Nandi and Senator for Homa Bay, kindly settle down. Clerk, you may proceed to call the first order.
Order number 1, communication from the chair.
Now, honorable senators, if you may recall, just before we went on a lunch break, there was a preliminary objection that was raised by the governor, which I undertook to deliver a ruling upon resumption, which is now. Now, honorable senators, on Monday, the 25th of August, 2025, as part of the bundle of documents submitted by the governor, pursuant to Rule 6 of Part 1 of the third schedule to the Senate Standing Orders, Messrs. Katwa Keegan, Katwa and Kemboy advocates, counsel for the governor sought leave to raise a preliminary objection to the hearing of the proposed removal from office by impeachment of Honorable Dr. Erick Mutai, setting out a number of grounds. At the start of the hearing today, Counsel for the Governor sought to be allowed to canvass the preliminary objection. In doing so, it became apparent that a number of the grounds that had been set out in the correspondence sent to the Senate on Monday, the 25th of August 2025, were not urged before the Senate today, and therefore I need not make reference to them. As is well known, the impeachment process belongs to the parties. The parties are best placed to navigate their cases, and the Senate can only make a determination on matters argued before it. It is for this reason that I stopped Counsel Elisha Ongoya for the County Assembly in his tracks when he sought to make reference to grounds of preliminary objection which the County Assembly, which the Governor had not prosecuted today before the Senate. Honorable Senators, ladies and gentlemen, the present communication is therefore limited to the preliminary objection as raised and canvassed before the Senate today prior to the adjournment for lunch. Now, Honorable Senators, ladies and gentlemen, Counsel for the Governor made submissions contesting the voting that took place at the County Assembly of Kericho and urging that the Senate finds that the threshold of 2/3 of all members of the County Assembly in support of the impeachment motion was not achieved. In this regard, Counsel stated that of the 47 members of the County Assembly, 18 members did not vote, and that consequently, the records as submitted by the County Assembly were incorrect and even fraudulent. Now, Counsel Keegan and Counsel Peter Wanyama made extensive arguments illustrating the inaccuracy of the technology deployed, including arguing variously that A, a number of members of the County Assembly voted more than once, B, persons other than members of the County Assembly and the administrator of the voting system could access the system, C, that contrary to the Kericho County Assembly standing orders, the system did not indicate the number of members who had abstained, D, the system did not have provision for voting by means of pressing a button as required by the standing orders. Instead, a link was sent to the phone numbers of the members. And lastly, the use of payroll and ID numbers as passwords could easily and was indeed compromised, and therefore the system was neither secure nor accurate. The thrust of the County Assembly's response to the preliminary objection raised was to urge the Senate to find that this was not a proper preliminary objection and consisted of mere sensational allegations. Counsel drew the attention of the Senate to the decision of the High Court in the matter of Governor Sonko, as he then was, in the High Court petition number E425 of 2020, in which similar contestations arose as between the County Assembly and the Governor on the number of members of the County Assembly of Nairobi who had voted in favor of the impeachment motion and whether the 2/3 threshold had been attained. In that case, the court held that in view of the contradictory evidence adduced by both parties, coupled with the lack of expert evidence, the court was unable to find that the 2/3 threshold had not been met. Counsel further stated that the matter in which the system works and whether the allegations made by the governor's side about the integrity of the system was sound was a matter of ICT experts who will be required to adduce evidence in support of the County Assembly's position or the governor's position, whichever. Arising from the preliminary issues canvassed, the following are the issues that require determination by the Senate. 1, whether the preliminary objection raised qualifies as a preliminary objection properly so called, and whether, therefore, a determination must precede the further progress of the current impeachment process. And two, if whether to the first issue is in the affirmative, then whether the voting on the impeachment motion in the County Assembly took place in accordance with the law, and whether the threshold required under Section 33(2) of the County Governments Act, Cap 265 of the laws of Kenya, was therefore made so as to qualify the continued progress of the present impeachment process. Now, honorable senators, ladies and gentlemen, the question of what constitutes a preliminary objection was well set out in the leading case of Mukisha Biscuit Manufacturing Company Limited versus West End Distributors, contained in the 1969 EA at 696. And it states as follows: a preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of pleadings, and which, if argued as a preliminary point, may dispose of the suit. Examples are an objection to the jurisdiction of the court, or a plea of limitation, or a submission that the parties are bound by the contract giving rise to the suit to refer to the dispute to arbitration. A preliminary objection raises a pure point of law, which is argued on the assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained, or if what is sought is the exercise of judicial discretion. A preliminary objection does not need evidence to be adduced as proof of its existence. It is limited to points of law and cannot be raised if a fact has to be ascertained. Now, honorable senators and ladies and gentlemen, drawing from the decision in the Mukisha Biscuit case, the issue of whether the impeachment of the governor met the threshold required under Section 33(2) of the County Governments Act, Cap 265 of the laws of Kenya, is a factual question that is contested. The governor has raised questions on the manner and integrity of the voting process, which calls for the Senate to interrogate the documentation and pleadings presented before it by both the County Assembly and the Governor of Kericho. It is noteworthy that counsel for the governor, in their own submissions, repeatedly asserted that the contestation was based on the facts of what actually transpired. Indeed, the governor has called the 18 members of the County Assembly whose vote is contested as witnesses to these impeachment proceedings. No summary determination of this matter is possible without these witnesses taken to the stand to give evidence and being subjected to cross-examination in the usual manner. The factual question of the number of members of the County Assembly who voted for the impeachment motion is a matter that calls for determination by the Senate. The only way for the Senate to determine these questions is to receive evidence on the matter, evaluate the same, and make a finding one way or the other based on the preponderance of evidence. It is important to recall that the Senate did, on the 14th of October 2024, vote to uphold a preliminary objection raised by the governor of Kericho on the ground that the threshold required for removal of the governor from office by impeachment, provided for under Section 33 of the County Governments Act, and Standing Order 74 of the Standing Orders of the County Assembly of Kericho had not been met. In those proceedings, there was no dispute as to the fact that the documents submitted in evidence by the County Assembly included a list of 31 out of 47 members of the County Assembly of Kericho that had voted in favor of the motion for removal from office by impeachment of the Honorable Governor of Kericho. The question for determination by the Senate in those impeachment proceedings was whether the two-thirds constitutional threshold was 31 or 32 members of the County Assembly. There was no dispute or contestation between the Governor and the County Assembly as to the following facts. A, the County Assembly of Kericho has 47 members, and B, only 31 members of the County Assembly voted in favor of the impeachment motion. The Senate, in those proceedings held on the 14th of October 2024, was only left with the task of determining the legal question as to whether the two-thirds constitutional threshold was 31 or 32 members of the County Assembly. That determination did not require the production of any evidence. On the 14th of October 2024, the Senate, by its vote, determined that the two-thirds threshold is 32. In the current impeachment proceedings, there is contestation between the Governor and the County Assembly as to the following facts. The members of the County Assembly who voted in favor of the motion, and B, the transparency and integrity of the electronic voting platform deployed on the 14th of August 2025. This is not to say that the objection raised by the Governor is not important. It is indeed fundamental. In fact, it is of great importance. It will set a very dangerous precedent if the Senate will be sent on a wild goose chase to conduct impeachment proceedings and vote on charges which are defective ab initio and on the ground that no lawful impeachment was undertaken. It therefore means that the Senate must make a determination one way or the other whether the threshold for impeachment was met. The real question before us, therefore, is only the stage at which that question is mature for determination. I therefore rule that since this matter of fact requiring the adducing of evidence, it will be determined by hearing both parties and entertaining evidence that they have in respect thereof. This preliminary objection is accordingly disallowed for being premature at this stage. In light of the importance of the question, though, the Senate shall determine the disputed facts prior to making a determination on the impeachment charges. I therefore further rule that at the conclusion of the impeachment proceedings and prior to the voting on the charges, the Senate will pronounce itself on its finding on the matter of the threshold and whether it was met. In the event that the Senate finds that the two-thirds threshold of 32 members of County Assembly was not met, then the impeachment proceedings shall immediately determine, and the Senate shall now proceed to determine the impeachment charges. If, however, the Senate finds that the two-thirds threshold of 32 members of the County Assembly was met, that is, after hearing the evidence, then the Senate shall proceed to determine if the impeachment charges have been substantiated by voting thereon. The preliminary objection is therefore fails, as the same shall now be subsumed in the main hearing of the impeachment proceedings. It is so ordered. Thank you. Next order.
Order number 2, hearing and determination on the proposed removal from office by impeachment of Honorable Dr. Erick Mutai, Governor of Kericho County.
Now we will proceed to hear the opening statement by the County Assembly. Thereafter, we will move to hear the opening statement by the Governor. Each party has 30 minutes to do that. Counsel for the County Assembly, you may now take to the floor.
Thank you so much, Mr. Speaker, and thank you so much, distinguished senators. It gives me great pleasure once again to appear before you on a matter involving a motion for the proposed removal of a governor from office by way of impeachment. Mr. Speaker, sir, distinguished senators, before I get into the pith and marrow of my opening statement, I'll begin by reflecting on the fact that coincidentally, today is the 27th day of August, the year 2025, and therefore today marks precisely 15 years to the hour from the day we adopted, enacted, and gave to ourselves and to our future generations the Constitution of Kenya 2010. I also take note of the fact that in his recent presidential proclamation of August 27th as Katiba Day, His Excellency, the President, noted that it is befitting for the people of Kenya to commemorate this day as a reminder of our collective duty to obey, preserve, protect, and implement the Constitution. I finish that observation by noting that that proclamation also observed that Katiba Day shall be observed throughout the territory of Kenya, including our diplomatic missions abroad, as the day dedicated to renewing our shared commitment to the ideals of our Constitution by fostering national dialogue on constitutionalism, governance, and the rule of law. The County Assembly of Kericho has, by instrument of this motion, caused this House to sit here today and engage in this conversation, this dialogue on constitutionalism, governance, and the rule of law through the prism of the county government of Kericho. It is in the place of an opening statement, Mr. Speaker, sir, to lay out the broad outline of one's case. And therefore, I wish to proceed by laying out the broad outline of the case of the County Assembly of Kericho. The case of the County Assembly of Kericho is that generally, once elected representatives like the governor now before you have some prescribed tenure in office, in our case, a 5-year tenure. But the case by the County Assembly of Kericho is that there is an unwritten word in that 5-year tenure, the words being a 5-year good behavior tenure. The County Assembly of Kericho have brought before you their governor, and they are telling you he is of bad behavior. They now wish to lay out the basis for their assertion that having observed their governor for slightly over 2 years that he has been in office, his conduct reveals bad behavior. The County Assembly of Kericho takes note of the fact that this House ordinarily summons county governors and county executives and sometimes decries the rot in county governments. What the County Assembly of Kericho has done is that internally, through its standing committees and through its ad hoc committees, it has undertaken an oversight role of the county governor and his executive. So they have had a scientific method of approaching this matter. At the conclusion of their investigations through standing committees and ad hoc committees, the rot in the government of the governor now before you has come to the fore. They have therefore carried that rot to you as evidence of bad behavior and will be inviting you to consequently vote for the removal of this governor from office. How will they do that? For example, when the time will come, they will take you through payment vouchers for multiple transactions. Multiple transactions. And when you study those vouchers and their supporting documents, part of the data that you'll come across is found in volume 4D of the County Assembly's documents. So that, distinguished senators, when you look at volume 4D of the County Assembly's documents, you will see a summary of what various payment vouchers and other